All right. Welcome back to our second part B of training number 2, which is about the case law. Last video, which we just covered, we covered 3 of the main cases, the main players in our Article 2 issue, which are Humphrey's Executor, Morrison v. Olson, and Sela Law. So if you didn't get to watch that video, would encourage you to watch that, or at least refresh yourself on those 3 cases. Again, that's Humphreys, Morrison, and then Sela, which are kind of the 3 main players. In this video, I want to talk about the remedy issue, which is a little bit more complex. So I hope you, at least if you watch one of the 2 of the videos between that one and this one, I almost hope that you watch the remedy video if you're not going to watch both, because this one is a little bit more complicated. There are 2 main remedies that are available for Crosby if Crosby wants to be reinstated. So remember that we're reaching this issue because we're saying, if the president wrongfully removed Crosby, what next? What do we do? Do we put Crosby back in his seat? And there are 2 main ways that we can do it. There's what's called a legal remedy and what's called an equitable remedy, which I'll describe in more detail in a minute. The legal remedy is to reinstate Crosby through a mandamus. So we would issue a mandamus to the president and order the president to reinstate Crosby. The equitable remedy is to reinstate Crosby through an injunction. The difference between these 2 we'll see on the next slide, but in general, an injunction is to prohibit the president from firing him, and a mandamus is to encourage the president, not encourage, but order the president to reinstate him. Either way, they have very similar outcomes. Let's talk about the main difference between mandamus and injunction. It comes from the English court system. In English courts, there were 2 separate systems of law. In America, they've been merged since 1938. But in the English court system, they are 2 separate courts. So the court of law, well, I've made black and white because I want you to think of the courts of law as black and white. That's where we get legal duties from. You can hear law and legal, it's the same sort of thing. Courts of law were supposed to settle simple matters that were black and white when somebody owed a clear duty to somebody else. Most often, that resulted in damages going from one party to the other. So if you had harmed somebody else, they would just look through the case law to see what sort of damages were available, and then they would order you to pay damages to the other person. The mandamus comes from a court of law because a mandamus is ordering somebody to do something that they have a clear and indisputable legal duty to do. So a mandamus is an order to somebody when they have a clear and indisputable legal duty to perform something. Now let's talk about court of equity. Again, we'll cover these in more detail. We're just touching the surface. So if you don't fully understand them, just keep listening. I've made court of equity look a little bit more colorful because I want you to think about courts of equity as much more colorful. Courts of equity are supposed to be flexible. In contrast to black and white courts of law, where a proclamation would come from a court of law about something that's clear and indisputable. Courts of equity are supposed to be for people to receive full recompense, full restitution for whatever they've lost. The word equity really means sort of like full equality, bringing somebody back to wholeness. So when we think about courts of equity, we think if money can't solve your issue, maybe a court of equity could solve your issue because it's more flexible. So let's say that somebody tore down your fence. Now, a court of law could order the person who illegally tore down your fence to pay you money because they have a legal duty to compensate you for the fence. But maybe you say, I don't really think money is going to solve my problem. I want you to build my fence back up. A court of equity could order that other person, theoretically, to give you a fence and build that fence up back. So courts of equity dealt with property rather than just money or proclamations. Courts of equity deal with property, saying, back in England, it would be like, give somebody back their cow, give somebody a house, give somebody back their fence, give somebody back their rifle. It's a lot more flexible. And injunctions are the remedy that comes from courts of equity. That distinction means that there are really 2 remedies available, distinct remedies. You've got a mandamus to put Crosby back in his seat, an order to the president. I'd order you to put him back in his seat. Or a more flexible, equitable remedy, an injunction, which orders the president to stop doing whatever he was doing and to give Crosby back his seat. Now, technically, there are 4 options that the court could do. We just talked about the equitable and legal remedies, injunction and mandamus. There are also 2 others. One is called declaratory relief, and declaratory relief simply declares, as the name implies, that the person would be entitled to a seat. But importantly, there are no teeth to that declaration. There's no punishment, no enforcement. If an injunction or a mandamus were disobeyed, then the person who disobeyed the injunction or mandamus would be held in contempt of court because they've disobeyed a lawful court order. But for declaratory relief, they're declaring who is right, but they don't have any punishment if you refuse to follow it. So it's similar to if you went to your therapist and the therapist didn't say, go do this or else you're not coming back to therapy. Rather, the therapist said, well, this is what is right to do, and let you kind of decide whether you wanted to do it or not. Now, I'm not trying to say that in a declaratory relief, the courts are like, yeah, do whatever you want. Of course, they want the person to give the seat back to Crosby, but there's simply no teeth to that relief. And then the last option is damages. You could pay Crosby money as compensation. The reason why I've called that weak is because it's not quite what Crosby wants. I don't think either of the latter two is what Crosby wants. Respondent is going to be who's representing Crosby, is going to be asking the court for a remedy to reinstate Crosby. So they don't want just a declaration, and they don't want just money. They want options 1 or 2. Whereas the petitioner does not want to reinstate. They're asking the court to reject the request for these 2 remedies. And instead, they're asking for either declaratory relief or damages. Now, the odd thing about this case is that the petitioner speaks first, which means you'll hear the petitioner saying, don't accept the respondent's proposition before the respondent even speaks. So here's how it would look. The petitioner speaks first, and they might say, don't grant an injunction. Don't grant a mandamus. They may, but they don't have to. They may say, do grant a declaratory judgment since it's weaker. And they may, and they don't have to, say, do grant damages. But the key thing is that they just have to say no to injunction and no to mandamus. We do not believe that this court should grant an injunction or a mandamus. The respondent does not have to do both, but they could. They could certainly ask for both. They could ask for both an injunction and a mandamus, or they could ask for neither. If they ask for an injunction, they can choose to also ask for mandamus, or they could choose to just ask for an injunction and vice versa. The key point is they just need to ask for one or the other. And they could alternatively also respond to declaratory judgment and damages, but they don't have to. The key thing is they just want to ask for an injunction or a mandamus. Okay, if you're a respondent, or you're a judge, so you're never going to be respondent, but you might think, what should the respondent choose to ask for? Should they choose to ask for an injunction or a mandamus? Should they ask for an equitable remedy, which is injunction, or a legal remedy, which is mandamus? Or they could ask for both. So as I said already, equity deals with property and legal deals with money and proclamation. And so one argument for why we can't ask for an injunction is because of this quote, and pay close attention to this quote from a case that's in our packet in Ray Sawyer, in regard to Sawyer. A court of equity, think injunction, has no jurisdiction over the appointment and removal of public officers. The jurisdiction to determine the title to public office belongs exclusively to courts of law and is exercised by mandamus. So notice here that if in Ray Sawyer is correct, court of equity has no jurisdiction to reappoint Crosby. They don't have jurisdiction. Therefore, courts of equity, which produce injunctions, means that injunctions won't work, and only a mandamus could possibly work because it says the jurisdiction to determine that is exercised by mandamus. That's what In re Sawyer says. So if you buy this argument, which I'm going to show a counter argument to this in a second, but if you buy this argument, only a mandamus could possibly work according to this quote from In re Sawyer. However, there are different theories about whether this case still holds true. A minute ago, I told you that in the English courts, they were split, courts of equity and courts of law. But in America, those courts have been merged since 1938. Now, this case that I just showed you, In re Sawyer, which said that their equity cannot grant you a reappointment, that case is from 1888, which is 50 years or so before the merger of law and equity. So there are two theories about how In re Sawyer still applies. Number one theory we could call the historical dividing lines theory. This theory says that modern civil courts, which do have the power of law and equity, could either grant a mandamus or an injunction, but each of these comes strictly from the court, from the power that the modern civil courts have. So a mandamus still requires court of law, and an injunction still requires court of equity. In other words, there are still strict and stringent requirements. If I were to grant a mandamus, it has to be the requirements of the court of law. If I grant an injunction, it has to be the requirements of the court of equity. Now, theory number 2 is what we might call a full merge theory, which is that after the modern courts merge the courts of law and equity, you can grant a mandamus or an injunction, and you don't have to prove that it's exactly from the court of law or exactly from the court of equity. These two terms just refer to general remedies, which, yeah, certainly you have to meet some of these criteria, but they're a little bit more blurry because mandamus and injunction simply are two different words of two different ways of describing the sorts of remedies that will come from the modern civil courts. That's why I've made them green. They come from the modern civil courts, not strictly from the court of law or the court of equity. These two theories are both valid theories. In case you're wondering, like, is there one that's much more prominent over the other? You'll hear smart people on both sides debate both of them. Again, one side will say, well, if you ask for a mandamus, you still have to prove that it comes from a court of law. And if you ask for an injunction, it has to come from the power of the court of equity. Whereas the full merge theory will say, look, ask for an injunction and prove that it comes from one of these two courts. It doesn't really matter. Or ask for a mandamus and prove that it comes from one of these two courts. It doesn't really matter. Show that the court has the power to grant a mandamus or an injunction, but it doesn't need to be strict like it would under historical dividing lines. If you take theory 2, injunctions can work. Because remember what I just showed you. Under In re Sawyer, injunctions simply cannot work. Here, let me show you. Oops. Remember this quote that I showed you from Sawyer. A court of equity has no jurisdiction over the appointment and removal of public officers. So injunctions won't work under theory 1. This is theory 1. But under theory 2, injunctions actually could work. And here's a quote. This is not in our case packet. This is just a memorandum opinion from the DC Circuit in, I believe, the case of Wilcox, Trump v. Wilcox. Not in our packet, so you can't really quote it, but you can know this. This is what they say. Historically, requests for reinstatement were styled as writs of mandamus before courts of law instead of requests for injunctions before courts of equity, as Trump's cited cases reflect. So they're like, historically, we used to have these dividing lines. But, catch this, after the merger of law and equity in the federal courts over 80 years ago, however, that distinction makes no difference and does not render improper the injunctive relief plaintiff requests. In other words, because of the merger of law and equity, you could ask for an injunction under the combined powers of law and equity. It's that green color that I was showing you. It's just from the combined court overall, you can ask for an injunction. And this case is in our packet, Swan v. Clinton, and they say, we note that a request for an injunction based on a general federal question statute is essentially a request for a writ of mandamus in this context. So asking for an injunction is essentially asking for a writ of mandamus because of the merger of law and equity. So so you say, okay, I'm looking at two theories. The theories make sense to me, but I just don't see why I would choose one or the other. Like, why would the respondent want to choose mandamus or injunction? And hopefully this can prompt you to ask some questions about why are you asking for a mandamus rather than an injunction? Or what do you think about the theory of how the two courts have been merged? Do you agree with the merge theory? So there's one key reason why you'd ask for a mandamus on respondent, which is that you're adhering to the historical dividing lines. You're saying courts of equity historically were not able to provide reinstatement, but courts of law were historically able to grant mandamus. So we can ask for mandamus, not an injunction. Why would you ask for an injunction then? If you believe in theory 2, it's because it's more common in the modern era to ask for injunctions, although many people who are asking not just for injunctions, but for injunctions or mandamus. They kind of ask for both. It's more common in the modern era to use the term injunctions than mandamus. And it's also slightly easier to win under an injunction because the requirements for an injunction is just if the official does something illegal, then he will then the courts can issue an injunction. Whereas for a mandamus, they have to fail to perform a ministerial duty, and the definition of a ministerial duty is a little bit up in the air, because the definition of a ministerial duty is like something that you don't have discretion about. We talked about this in the case packet video, but defining what discretion means is a little bit ambiguous. So it's easier to win an injunction than a mandamus. I'm not going to say which is better, because I don't even know if there is a better. It kind of depends. I just want you to be aware of this so that you can engage with our students in a helpful way, so that you can ask them questions about why they've chosen a mandamus or an injunction, ask them questions about the merger, ask them questions about In re Sawyer and how they respond to it, ask them questions about the Swan v. Clinton quote about how asking for an injunction is basically asking for a mandamus. So all of those things I hope can just spur good conversations and good colloquies with the students. So in terms of the cases, we've covered some of them. Some of the cases that we've covered are In re Sawyer, and then I just showed you on the last slide that talking about how mandamus equals the ministerial duty is from Kendall, and then talking about how an injunction means the official acted illegally is from Youngstown. The second class of cases is a whole nother argument. So far we've been talking about injunction or mandamus. Now I want to talk about how this second set of cases, the second argument, which is, can the courts order the president to act? To just set this up for you, it seems a little bit radical that we could order the president to act in a certain way if you're the courts, because the president should be able to control his own decisions. Why should the courts tell the president how to act? Especially if he has discretion. But even if he doesn't, it seems like a radical move for the courts to tell the president to act in a certain way and to exercise his discretion in a certain way, mostly because that violates the separation of powers. That means that the judicial is ordering the executive to do a certain thing, which means that the judicial has basically taken an executive action. There are 4 key cases here that discuss this question of ordering the president to act: Marbury versus Madison, Mississippi v. Johnson, NTEU v. Nixon, which is a DC Circuit case, and Franklin v. Massachusetts. Let's talk about each of them, and that will conclude our video for today. So starting with Marbury versus Madison, very old case, actually the first major case, landmark case in our history, SCOTUS history. Marbury versus Madison has this quote: "It is not by the office of the person to whom the writ is directed, but the nature of the thing to be done, that the propriety or impropriety of issuing a mandamus is to be determined." Read that quote again. It's not about the status, the office of the person who the mandamus or the injunction is being directed to. It's about what we're asking him to do that makes it proper or improper to issue a mandamus or an injunction. How would this apply to this case? It doesn't matter that he's the president. It doesn't matter his status, his title, his office. What matters is, are we asking him to do something that is his discretion, which we can't do, or asking him to do something which he has a ministerial duty to do? Now, technically, this quote from Marbury versus Madison was not about the president. It was about the Secretary of State. But we could cross-apply it to the president and say, nobody's above the law. It doesn't matter that he has the title and the office of president. It matters whether we're asking him to do something which he has a ministerial obligation to do. Number 2 is Mississippi v. Johnson. In this case, the state of Mississippi in the era of Reconstruction, right after the Civil War, was trying to prevent Johnson from appointing Union military generals to oversee Reconstruction in Mississippi. Remember, Mississippi is a southern state, so they don't like the Union. And Andrew Johnson was trying to pass these Reconstruction acts, which forced military generals to be present in the southern states. So they tried to stop Johnson from doing so, and the court said this court has no jurisdiction over a bill to enjoin the president in the performance of his official duties. So this is the opposite of what Marbury versus Madison says. It's Mississippi v. Johnson is saying this court does not have the ability to tell the president how to do his duties, because the president has control over his own duties. The courts can't tell him what to do. Number 3 is NTEU v. Nixon. This case is a DC Circuit case, so it's not Supreme Court. They conclude, in line with Marbury versus Madison, that you can issue a mandamus to the president. So if I were to arrange this, Marbury and NTEU are in the same category, and then Mississippi and later Franklin v. Massachusetts are in the other category. Here's what NTEU says. This court concludes that jurisdiction in this case exists to support the issuance of a writ of mandamus directing who? The president to effectuate the pay raise sought by the plaintiff. Now, stop for a second. It's saying, we have the authority to mandamus the president. We can tell him what to do. They believe, looking at past cases, that there's no reason to think that the president is above the law. They end up saying, and here's a throwback to what we just discussed, that they should instead act pursuant to the provisions of the Federal Declaratory Judgment Act. In other words, they say, yes, we have the power to issue a mandamus, but we don't really want to be so controversial, so we'll just issue a declaratory judgment. Remember, declaratory judgment is just saying what should happen, but not having any teeth to it. So they are acting pursuant to the provisions of the Declaratory Judgment Act rather than rather than ordering a writ of mandamus. But the point is that they conclude that they do have the ability to issue a writ of mandamus and then just back off and say, we're just not going to do it in this case just to be safe, but we think that we have the power to do so. Okay, last case is Franklin v. Massachusetts. As I said, Franklin and Mississippi are in the same category. In the concurring opinion by Justice Scalia, he writes this. Historical tradition supports the view, which I think implicit in the separation of powers established by the Constitution, that the president may not be ordered to perform particular executive acts at the behest of the judiciary. He thinks that it's part of the separation of powers and respect for the high office of the president. That the president can't be told to perform particular executive acts because the judiciary told them to do so. The president is his own branch. He's the executive branch. And the judiciary cannot tell him what to do. It's very disrespectful, in Scalia's opinion, and disrespectful of the high office of the president for the judiciary to tell him what to do. Now, I want to close with this because maybe you're thinking, it seems strange that we can't tell the president what to do because he shouldn't be above the law. Like, could he do something completely illegal and the courts do nothing about it? And here's my answer to you. If the president does something completely illegal, there is recourse. There's recourse already. That recourse is called impeachment. If the president were to, jail his political opponents, if the president were to, in flagrant violation of Congress and order something that Congress had not given him the power to do, there is impeachment available if the president refuses to back down. And that is listed in the Constitution, enumerated as a remedy for wrongfully acting presidents. What is not listed in the Constitution is for the judicial branch to tell the president, order him what to do. I don't want to say that that means that the judicial branch cannot control the president. I think this is an open question. I think all of the questions in this packet are open questions, both the Federal Reserve questions and interpretation questions, and whether you should use a mandamus or an injunction. All of these are open questions. I think that they're for the mooters to decide, for you to question them about. I want to give you these arguments so that you can question them and continue to press them, ask them the best questions so that you can have the best discussion. That's our goal here, is to have judges just asking constant questions. Students love questions. They love when judges are asking them questions the entire time. So don't feel afraid to interrupt them, ask them lots of questions, use some of the material that I've provided you with. But in any event, if you have any questions for me and want to get more clarification, again, you can email etong@hsmca.org, and I'd be happy to answer your questions. Thanks so much again for tuning in. We appreciate your time. It's invaluable to us and to the students. Looking forward to seeing you all at a tournament.